Good afternoon, everyone. My name is Dan Scripps, Chair of the Michigan Public Service Commission, and I call this meeting of the Commission to order on November 6th at 2025 at 1:06 p.m. Madam Secretary, please call the roll.
Chair Scripps.
Present.
Commissioner Paratick.
Present.
Commissioner Myers.
Present.
Mr. Chair, you have a quorum.
Madam Secretary, today's meeting is being held in person at the Commission's office here at 7109 West Saginaw Highway in Lansing. We are also hosting this meeting remotely using Microsoft Teams. Telephone relay service is available through the function. If you are participating via Microsoft Teams, you may also turn on the live captions by clicking on at the top right of your Teams window, then clicking on language speech from the drop-down menu, finally clicking on turn on live caption. As indicated in the notice for today's meeting, if we lose the remote connection, the Commission will not recess. However, the meeting will be recorded for reference on the Commission's website. In addition, the Commissioners can receive comments via LARA-MPSC-commissioners@michigan.gov. That's LARA-MPSC-commissioners@michigan.gov. And for reference, this email is also today's meeting notice. We'll have the opportunity for the public to make comments as provided in the agenda. A few notes about this. Comments are limited to 3 minutes and one per person. If you would like to make verbal comments, you must do so in person or remote Microsoft Teams or by calling into the meeting. Individuals attending in person and who want to make a verbal comment, fill out a comment table near the podium. Individuals participating remotely by Microsoft Teams and who want to make a verbal comment, you may click the raise hand button at any time to be queued up for comment. Individuals participating remotely by phone and who want to may press *5 at any time to be queued. Public commenters on both Microsoft Teams and on the phone are added to the same speaker queue. So please do not lower your hand or press *5 again, or you will be in line. Finally, to minimize disruptions, attendees participating by Microsoft Teams or by phone will be muted until we reach the time for. First order of business is approval of the agenda for today.
Move for the approval of the agenda for today's.
I second the motion.
Is there any discussion? I'll have a vote to approve today's agenda. All those in favor of the motion say aye.
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 Aye. Any opposed? Motion carries by a unanimous vote and the agenda is approved. Next item of business on the agenda is approval of minutes from the October 9, 2025 Commission meeting.
The approval of minutes from the Commission meeting.
I second the motion.
Is there any discussion? I'll have a vote to approve minutes from the October 9, 2020 Commission meeting. All those in favor of the motion say aye.
Aye.
Aye. Any opposed? Motion carries by a unanimous vote. The Commission meeting minutes of October 9, 2025. Next item of business on the agenda is the approval of the orders and minute actions on the consent agenda, and today the Commission is assisted by Staff Attorney Charlie Cavanaugh. Mr. Cavanaugh.
Good afternoon. Today's consent agenda consists of 6 communications matters, 6 electric matters, 2 gas matters. Proposed orders and minute actions for these have been thoroughly.
Mr. Kavanaugh, I move for the approval of orders and minute actions on the.
I second the motion.
Is there any discussion? Vote on the motion to approve the orders and minute actions on the consent agenda. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by a unanimous vote. The orders and minute actions on the consent agenda are. Mr. Kavanaugh.
Item 4A1 is case number U-21904, which involves a matter on the Commission's own motion, initiating an action by CMC Telecom and Internet, Inc. to show cause why it should not be found in violation of the Michigan Telecommunications Act. Staff member Wendy Thalen will describe this order.
Good afternoon, Commissioners. After the receipt of 2 customer complaints in the summer and fall of 2024, and upon further investigation of those complaints by staff, the Commission issued an order on April 24th, 2025, in case number U-21904 for CMC Telecom and Internet, Inc., which I will also refer to as CMCTI, to show cause why it should not be found in violation of the Michigan Telecommunications Act for providing telephone service without a license issued by this Commission and for failure to register with the Commission that it was providing other unregulated voice service in this state as required under the Act. During its investigation of these complaints, the staff found that despite the lack of a license to provide basic local exchange service, no registration in the Commission's intrastate telecommunications service provider database, and a showing by the Michigan Department of Licensing and Regulatory Affairs Corporation's online filing system that the company was dissolved in 2021, and additionally, no record of the company in the Federal Communications Commission's Form 499 filer database, The customer records and invoices provided to staff show that the company was providing voice service. The situation was more concerning due to the fact that CMCTI's application for a basic local exchange service license was dismissed by the commission in 2018, and the company did not reapply for a license, nor did CMCTI register with the commission to provide other unregulated voice service. While CMCTI initially responded to staff's inquiries with regards to these customer complaints and noted that they did not have any active telecommunications customers in Michigan, the company failed to respond to additional staff inquiries, prompting the staff to make multiple additional attempts to obtain further information from CMCTI, to which they did not respond. The April 24th order in this case also required CMCTI to file a response to the allegations addressed in the order and appear at the May 2025 pre-hearing conference scheduled for this case. CMCTI did not respond to the order, failed to participate in the hearing process, and has made no filings in the docket to refute the staff's claims, and the staff presented its testimony and briefs in this case unopposed. There were also no interventions filed. On August 19th, 2025, Administrative Law Judge Sally Wallace, who was assigned to this case, issued her decision adopting the staff's recommendations that the commission assess CMCTI a fine of $500 per day for a total of $61,000 for violations of Section 301 and 211A of the MTA for providing basic local exchange service without a license and failing to register with the commission during the time period from at least April 1st, 2024 through May 31st, 2024, to require CMCTI to issue refunds of the paid invoices to the two complainants, and to require CMCTI to cease and desist from providing unauthorized telecommunications services in Michigan. The order before you adopts the findings of the ALJ.
Thank you, Ms. Thalen. I move for the approval of the order in case number U-21904.
I second the motion.
Is there any discussion? Is there any discussion?
Yes, please. Thank you, Chair. I'd like to just begin by thanking our excellent telecommunications staff for their work on this case, including Ms. Thalen and her whole team. This is a clear case of a violation of the Michigan Telecommunications Act, and our staff was able to identify the issue and order CMC Telecom to cease and desist providing unlicensed basic local exchange phone service. As described by Ms. Thalen in her presentation, this came to our attention when 2 customer complaints were filed with the Commission. Our telecommunications staff then thoroughly investigated the complaints and found that an unlicensed company was providing voice service to at least 2 customers. Basic local exchange service, or landline telephone service, is crucial to customers who rely on it. For example, customers who need to dependably communicate during an emergency, for rural customers who would otherwise have unreliable or prohibitively expensive service, and for businesses and critical services like hospitals, schools, or other businesses that need to maintain redundancy in case their voice over internet protocol or VoIP systems fail. Landline services provide access to lifeline programs that subsidize basic phone service to our most vulnerable and to ensure universal communication access for everyone. Importantly, it's still the law, under Michigan law and under the FCC, that everyone must have access to basic telephone service. So under this backdrop, it's very concerning to have a bad actor violating the law in an attempt to provide unreliable, unlicensed telecommunication services. The order before us not only orders CMC Telecom to cease and desist operations in Michigan, as described by Ms. Thalen, it also fines the company $500 per day over the period of known violation and directs the company to issue refunds to the 2 customers who filed complaints with us. So thanks again to our vigilant telecommunications team for your work on this case.
Thank you, Commissioner Paratic. I echo those comments and express my appreciation for the staff's diligence in this regard and frustration with the activities of this unlicensed provider. As Ms. Thalen noted, they had previously applied for a license. That license was ultimately rejected in 2018. They had an affiliate who had previously been licensed as a telecommunications provider of basic local exchange service in Michigan. That license was revoked for separate violations of the Michigan Telecommunications Act in March of 2021. And so I appreciate the work of staff in responding not only to the specifics of the complaints that we received, but uncovering a pattern of broader non-compliance with Michigan law, as well as Ms. Thalen noted, FCC provisions and indeed corporate registry with the licensing, with the Department of Licensing and Regulatory Affairs. My only frustration in this case is that even given the known violations, our ability to sanction this company is limited by the 2 known violations for the 2 months in which we knew that those violations occurred, against the backdrop of the high likelihood, in my view, that there were additional months of service being provided in an unlicensed manner and additional customers who may have been impacted. So again, appreciation for our staff's diligence in this, frustration with the activities of this company, but hopefully this cease and desist notification, as well as the fines imposed today, provide a clear indication both to this company and others that we expect them to follow the law and commission orders in the provision of basic local exchange service in Michigan. Is there any additional discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
Aye.
Aye. Any opposed? The motion carries by unanimous vote. The order in case number U-21904 is approved. I was hoping you didn't have a change of heart. I recognize Mr. Kavanaugh.
Item 4A2 is case number U-21913, which involves an application, as amended, filed by UP Fiber Inc. for a permanent license to provide basic local exchange service in the state of Michigan in certain areas served by AT&T Michigan. The order before you grants the permanent license.
I move for the approval of the order in case number U-21913.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by unanimous vote. The order in case number U-21913 is approved. I recognize Mr. Kavanaugh.
Item 4B1 is case number U-15800, which involves a matter on the Commission's own motion to implement provisions of Public Act 295 of 2008. The order before you invites comments on the Commission staff's August 29th, 2025 final report and recommendations. Comments must be filed no later than 5 p.m. Eastern Time on December 8th, 2025.
I move for the approval of the order in case number U-15800.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by a unanimous vote, and the order in case number U-15800 is approved. Recognize Mr. Kavanaugh.
Item 4B2 is case number U-20604, which involves 2 applications filed by Consumers Energy Company requesting ex parte approval of a power purchase agreement between the company and Pivot Energy MI10 and a power purchase agreement between the company and Pivot Energy MI19. The order before you approves the applications.
Mr. Kavanaugh, I move for the approval of the order in case number U-20604.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by a unanimous vote. The order in case number U-20604 is approved. I recognize Mr. Kavanaugh.
Item 4B3 is case number U-21816, which involves an application filed by Consumers Energy Company requesting ex parte approval of a build transfer agreement to acquire the 45th Parallel Solar Project. The order before you approves the application.
I move for the approval of the order in case number U-21816.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? Motion carries by a unanimous vote. The order in case number U-21816 is approved. I recognize Mr. Kavanaugh.
Item 4B4 is case number U-21859, which involves an application filed by Consumers Energy Company for ex parte approval of certain amendments to rate GPD. Staff member David Isaacson will describe this order.
Good afternoon, Commissioners. On February 7th, 2025, Consumers Energy Company filed an application seeking ex parte approval of amendments to company's rate GPD tariff to add a data center provision to its general primary demand rate. The purpose of this provision was to ensure that accommodating the growth in data center customers would not create unacceptable risks for the company or its customers. On March 13th, the Commission issued an order converting this matter into a contested case to develop a thorough record on the unique and significant cost implications of serving data center customers. Consumers received inquiries for over 15 gigawatts of new data center load, which is more than double the company's current peak load. The state's two largest electric utilities, Consumers and DTE, have each announced agreements with new data center customers with demands over 1,000 megawatts each. The scale and rapid growth in energy required to serve these customers represents a unique challenge for regulators. One particular challenge is the possibility that these new and uniquely large customers may create stranded assets due to the rapid influx of new costs to serve them and uncertainty about the longevity of this relatively new energy-intensive industry. A wide variety of proposals for addressing the impacts of these customers on the regulated utility and its customers were considered in the order before you, which I'm going to highlight now. The order applies the new tariff provision to any large load customer, not just data centers, with a minimum service threshold of 100 megawatts with no load factor requirement. For the rest of this presentation, I'll refer to large load customers instead of data center customers, but of course the provision will still apply to data centers that meet the eligibility criteria. The company does not currently have any customers that would require to take service on this provision, so it will only apply to new large load customers. The order requires a minimum contract of 15 years, a minimum billing demand of 80%, a ramp-up period of up to 5 years, and automatic contract extensions of 5 years, and required 4 years of notice for contract termination. The order also requires potential customers to pay an administrative fee, which will be reconciled to actual costs. Altogether, these requirements ensure that large load customers remain in service long enough that they will fully cover new and embedded costs, while also giving the company time to plan for unprecedented changes in its overall load. The order sets an exit fee for leaving service before the end of the contract, equal to the minimum monthly bill times the number of months remaining on the customer's contract. The company must reasonably attempt to minimize the exit fee if it can, for example, by reassigning leftover capacity to other customers. The customer, however, may not reassign its own capacity to other customers without the company's approval. The order allows a one-time reduction of capacity of no more than 10%, which requires a 4-year written notice. Further contract capacity reductions will be allowed if the customer pays the prorated exit fee on the excess reduction, or the company shows in an ex parte filing that an exit fee is not necessary. Finally, consumers may suspend service if the customer's usage exceeds 1 megawatt or more of its contracted capacity. To ensure the customer can and will pay the exit fee, the order also approves a default collateral requirement equal to half of the exit fee. However, the order allows some discretion on the part of the company to determine an alternative collateral requirement. The company may propose a higher or lower amount than the default, but must make a showing that it is reasonable and prudent, which brings us to the next topic. The company will be required to make an ex parte filing prior to each large load customer taking service. This filing must show compliance with the large load customer tariff requirements, show that the costs caused by those customers are not being subsidized by others, and provide support for alternative collateral requirement if requested by the utility. This filing should include detailed information on how the company plans to provide generation, storage, or other resources to serve the large load customer without subsidy from residential, commercial, industrial, or lighting customers. Requests for a special contract to serve a large load customer must also show that the full costs of that service are paid for by the customer under the provisions of the special contract. The Commission will endeavor to make a decision on these filings within 90 days. The order declines to make a ruling that imposes any specific cost allocation or rate design method. However, following the company's currently active rate case, but at least 3 months prior to its next case, consumers must file 6 distinct cost of service and rate design proposals, meant to analyze large load customers' impact on rates and their contribution to interconnection costs. These proposals include studies with direct assignment of costs, large load customers as a separate rate class, and using different cost allocators. Additionally, the order approves the company's proposed annual reporting requirements, which include data such as aggregated large load provision demand and energy use, changes in capacity requirements, and exit fees. The order determines that issues regarding the impact of large load customers on integrated resource planning, renewable and clean energy standards, and interconnection standards are best addressed in the relevant ongoing proceedings before the Commission, and declines to include any related mandates in the new tariff provision. The order before you represents the first order involving how to serve data centers and other very large customers. We expect the Commission will see more issues, proposals, and outcomes regarding large load customers like data centers for years to come. Today's order and the customer protections it includes is an appropriate starting point for this pivotal new era of utility regulations. Thank you.
Thank you, Mr. Isaacson. I move for the approval of the order in case number U-21859.
I second the motion.
Is there any discussion?
Yes. Today's decision reflects the commission's efforts to revise the rate GDP and find the right balance between customer protection and economic development. Due to the size, oh, I said it backwards. Find the right balance between economic development and customer protection due to the size of the customers assigned to the large load provision. As this market evolves and demand for new technologies continue to grow, our policies must allow the system to adapt, supporting new industries such as data centers while protecting customers. We recognize that the data center industry is still in flux both nationally and within our state. That uncertainty makes it all the more important to put protections in place now. We must be proactive rather than reactive, ensuring that growth occurs in a way that is responsible, equitable, and sustainable. As utilities and developers respond to this growing demand, we need to be mindful of the potential effects on rates and affordability for customers. The investments required to support large-scale industrial customers can carry significant financial risk, and if market conditions change, there is still a very real concern about stranded costs, investments for infrastructure that no longer serve its intended purpose but still need to be paid for. The commission determined a 15-year contract is appropriate due to it being approximately the life of an investment that will need to be made from PPAs or from self-built generation to support the load. We welcome growth and the opportunities it brings, but it must come with a measured and responsible approach that keeps customer interests at the forefront of the decisions we make. It's important to note that even though the commission is supportive, it is not on existing ratepayers to fund the efforts of project proposals to draw large load customers to the utility service territory. The commission's order today supports industry development and protects customers from undue risk.
Thank you, Commissioner Myers. Commissioner Perdick?
Thank you, Chair. So first and foremost, in my decision-making process for this order, my goal was to ensure that data centers and other very large loads added to consumers' energy's electric system do not cause cost increases for other customers. Data centers can provide critical services for national security, for American businesses, and for economic growth, as Commissioner Myers outlined. But these data centers also put strains on our infrastructure, including water use, land use, and energy use. Land use and water use are outside of the jurisdiction of this commission. So when reviewing this tariff, I focused on ensuring that all necessary measures are taken to prevent the very high energy use of these data center customers from impacting the electric bills of other consumers' energy electric customers. Additionally, data center customers can pose the risk of stranded assets, particularly the risk that our utilities will build out new generation to serve new load that may or may not materialize. Customers should not be unfairly burdened with paying for potentially stranded assets. To that end, contracts between the utility and the large load customers must be sufficiently protective of other customers. The tariff in the order before us addresses these concerns in a few ways, as outlined by Mr. Isaacson. I will highlight a few of the major ones. So first, it requires that minimum contract length, as Commissioner Myers highlighted. This helps to make sure that long-term investments that are made to interconnect and serve the new large load customer are paid for over at least 15 years. It also requires the new large load customer to pay a minimum amount over those 15 years. If the customer says that they are going to use a certain amount of energy and capacity, this tariff requires the company to pay for at least 80% of that energy and capacity, whether or not the customer actually uses it. This provides certainty that those long-term investments will be paid for, even if the customer uses less energy than they originally said they would. It also puts in place an exit fee that a large load customer must pay if they choose to end service before the end of their 15-year minimum contract. This is a substantial fee that is equal to the minimum monthly bill that I just described, multiplied by the number of months remaining on the customer's contract. Importantly, the order contains a method to protect other residential, commercial, and industrial customers from the possibility of over-optimism or over-speculation from the large load customers. The tariff in the order before us does this by requiring substantial collateral to be posted. The default level of collateral outlined in this order is equal to half of the exit fee and can only be changed by commission approval of an ex parte filing made by Consumers Energy. And the final term that I want to highlight is the filing in the filing is that we are requiring consumers energy to file for each new large load customer. So in this filing, consumers will be required to prove that any costs caused by the new large load are paid for only by the new large load. No other residential, commercial, or industrial customer may subsidize the costs or have their electric rates raised as a result of a new large load customer interconnecting to the system. This filing requires details on what generation will be used to serve the load and how the new customer is paying for those resources. The filing will be reviewed carefully by the Commission and Commission staff to ensure compliance. There are many other provisions included in this order, and I encourage everyone to read the issue brief that we have created, which will be posted on our website on the Consumer Information Be Informed page. And if you want even more information, you can read our full order that can be found on eDockets under case number U-21859. It was a lot of work for us to get to this point today to issue this order. And I'd like to thank all of the interveners who participated in this case. And I'd especially like to thank our staff who provided invaluable expertise to help us ensure customers are protected while allowing for progress and development. In particular, David Isaacson, Bill Stosick, Nick Revere, Jesse Harlow, Lisa Gold, and Stephanie Fitzgerald.
Thank you, Commissioner Paratic. And just a few words from me before we vote as well. I won't spend as much time on the particulars, but zooming out, I think it's a fair reading of the story of the 20th century to say that increasing load over the course of decades allowed for us to develop backbone infrastructure, both generation and the poles and wires that connected an ever-growing number of homes and an ever-growing number of electrified appliances, all while keeping rates in check, that the increase in the number of kilowatt hours sold ultimately helped defray the costs and in fact cover the costs without rate shock to customers. It's simple math. It's numerators and denominators, where the denominators in terms of kilowatt hours were growing faster than the numerators in terms of the fixed costs of the system. Put bluntly, that has not been the story of the last 20 years, where we've needed to replace old infrastructure in a time of limited to flat load growth, which has resulted in a significant increase in rates and affordability concerns becoming ever more front and center. And while those have been offset by squeezing some of the energy waste out of the system, and Michigan certainly has been a leader in that area, there are challenges in how we replace that old infrastructure. So data centers and the loads that they represent, as well as other large load customers, provide an opportunity in this regard. But they also look different than the load growth of the past, in part because we're talking about gigawatt additions at a time, as opposed to the more incremental issues. And that creates the challenge that this tariff is designed to address. It really is sort of a fundamental issue of how to take advantage of the opportunities that growth represents, as Commissioner Myers detailed, without adding additional costs to existing customers, a principle that's as foundational to utility regulation as the Bond-Bright principles that we look to, and in fact animates his first two principles of sufficiency of revenue to cover costs and fairness in how costs are allocated between customers. So the tariff includes a number of important provisions to protect against cost shifts and stranded assets, including the avoidance of existing customers ultimately holding the bag if data centers or other large load customers can't pay, in the form of the collateral provisions that Commissioner Paratic mentioned. It also provides, I think, some important flexibility based on this nascent industry, including the opportunity to ramp to the full level over a course of up to 5 years, the one-time opportunity to reduce the capacity obligation by up to 10%, plus more than that if the customer pays a prorated exit fee or is ultimately approved by the commission as being unnecessary, and the ability to enter into special contracts for the additional costs that are being incurred. So I think it provides an important balance in suggesting that Michigan is open for business from data centers and other large load customers, while also leveraging those potential benefits of the growth that they represent in a way that's good for all customers as well as the state as a whole. I do recognize that this likely adds an additional step in the process, at least early on, before we get the results of the comprehensive cost of service, and that could inform a new rate for these customers that ultimately ensures that the revenues from those customers over the terms of these contracts are sufficient to meet the costs involved. But I think even in that, we provide two opportunities to move forward in a meaningful way. First is through the filing that Commissioner Peretick mentioned, by which the utility may demonstrate through modeling and a cost of service study that the existing rate GBT is sufficient over the minimum term and minimum billing demand requirements to ensure that revenues exceed costs and avoid additional costs to existing customers. And the second, as part of that, is through the opportunity to consider on an expedited basis special contracts related to the additional generation and other storage, demand-side resources, load flexibility, et cetera, where the data center or large load customer agrees to cover the costs needed to serve that customer. And that can be included as part of these ex parte filings as well. So as both my colleagues have mentioned, I think this is a balanced approach, a reasonable one that suggests that we are open and indeed welcome the opportunity to serve new loads in Michigan, and particularly in this tariff in the Consumers Energy Service Territory, but in a way that ultimately sees those as a net benefit to the system as opposed to additional costs or risks that fall on other customers. And with that, we will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by unanimous vote. The order in case number U-21859 is approved. I recognize Mr. Kavanaugh.
Item 4B5 is case number U-21870, which involves an application filed by Consumers Energy Company seeking authority to increase its rates for the generation and distribution of electricity and for other relief. The order before you grants the Commission staff September 18th, 2025 application for leave to appeal, along with requested relief therein, grants Michigan Environmental Council, Citizens Utility Board of Michigan, Sierra Club, and Natural Resources Defense Council, Inc.'s motion for leave to respond, and strikes the amended return on equity provision set forth in the September 5th, 2025 amended scheduling memo, along with any evidence filed in response thereto and since admitted into the record.
Thank you, Mr. Kavanaugh. I move for the approval of the order in case number U-21870.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? Motion carries by unanimous vote. The order in case number U-21870 is approved. I recognize Mr. Kavanaugh.
Item 4B6 is case number U-21977, which involves an application filed by DTE Electric Company requesting ex parte approval of a one-time regulatory asset treatment of $19 million in deposits made to Powen LLC in accordance with an approved equipment supply agreement between DTE Electric Company and Powen LLC. The order before you approves the application as described in this order.
I move for the approval of the order in case number U-21977.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by a unanimous vote. The order in case number U-21977 is approved. I recognize Mr. Kavanaugh.
Item 4B7 is case number U-21979, which involves an application filed by Consumers Energy Company for ex parte approval to accrue an allowance for funds used during construction on construction work in progress for projects within the company's renewable energy plan. The order before you approves the application.
I move for the approval of the order in case number U-21979.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? Motion carries by a unanimous vote. The order in case number U-21979 is approved. I recognize Mr. Kavanaugh.
Item 4C1 is case number U-21960, which involves an application filed by Sprague Operating Resources LLC to become a licensed alternative gas supplier. The order before you approves the application with conditions.
I move for the approval of the order in case number U-21960.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? Motion carries by unanimous vote. And the order in case number U-21960 is approved. Nice, Mr. Kavanaugh.
Item 4C2 is case number U-21965, which involves an application by Wave Energy Michigan LLC to become a licensed alternative gas supplier. The order before you approves the application with conditions.
I move for the approval of the order in case number U-21965.
I second the motion.
Is there any discussion? We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by a unanimous vote. And the order in case number U-21965 is approved. We've now reached the time reserved for members of the public to address the commission. As mentioned in the notice for today's meeting, we will take public comments in the following order. First from individuals attending in person, and then from individuals participating remotely, either through Microsoft Teams or the phone, who have entered the speaker queue. As a reminder, this public comment period is for commissioners to listen to comments and concerns and not to answer specific questions. When providing comment, please indicate your name and where you live if you are willing to share so that we have it for our records. And again, please limit comments to one per person and keep them brief, no longer than 3 minutes. I don't see any comment cards here today, but I'll see if there's anybody attending in person who would like to offer public comment at this time. Okay, we will now turn to the public comments by the remote option, either through Microsoft Teams or the phone. For individuals participating remotely by Microsoft Teams and who want to make a verbal comment, you may click on the raise hand button to be queued up for comment, and when it is your turn to speak, please click on the mic button to unmute. Individuals participating through Microsoft Teams also have the option to turn on their camera. For individuals participating remotely by phone and who want to make a verbal comment, you may press *5 to be queued up for comment. When it is your time to speak, you may press *6 to unmute. Public commenters on both Microsoft Teams and on the phone are added to the same speaker queue and will be called upon in the order that they enter the speaker queue. We have 2 queued up at this point, so I will ask the person with the phone number with the last 4 digits 0558. If you could unmute your phone, we'd love to hear from you.
Sorry.
No.
I have a public comment. According to Michigan, you know, I live in southeast Michigan. Why is DTE asking that there be no public comments on this data center in Saline, Michigan? Just another example how the public is left without their legal right to make public comments. And this is regarding DTE opt-out meter. So when you talk about vulnerable population, DTE cut off the power to a 92-year-old blind woman because she did not want their smart meter. So I spent 8 hours yesterday waiting for DTE to come to my home. They said they were coming to put a new opt-out meter. They never came. They never called me. They get the blessings from your organization to treat people with very disrespectfully when in fact on their holding line it says we want to have a respectful conversation with you, but they don't respect their customers, do they? And I was waiting 8 hours, no, and they're playing games about this opt-out meter, which Google AI states there's an opt-out meter. The opt-out meter is an analog meter. But when DTE was cutting off everyone's power, they had analog meter on their building, didn't they? So it's corruption, public corruption and bribery. This company should not be allowed to give money to politicians or judges. And it's very nice they have a really nice relationship with the Michigan Public Service Commission, and the commissioners get jobs at DTE 79% of the time. And right. So when you talk about vulnerable population, you have never tested the opt-out meter to be safe. I should be able to have safe electricity in my home, and I don't. So, right. My husband would like to make a comment about the data center. Harriet.
Yeah, I seen on Channel 7 about the data centers and I guess it's in Saline. How are they gonna increase their load by 25% without raising customer prices? And also, what is the footprint of this data center gonna be? You know, how many acres or whatever?
Thank you, sir.
Is anyone there?
Hello?
Up next, we have Brian M.
Good afternoon, commissioners. I am also commenting on the data center. I'm in the tech industry. I am from Ann Arbor, and yeah, I just want to point out, like, yes, we can pass all these kinds of policies to try to make sure that the average person doesn't foot the bill, but inevitably we will, and inevitably, even if we don't pay the actual, increase in monthly bills, we will pay for it in our environments and in our noise pollution. And ultimately, it does not bring jobs. It does not bring business. The AI boom is a bubble, a bunch of companies investing into each other and feeding into themselves and giving a lot of fun benefits to power companies in different areas where they get to, ratchet up the rates with a convenience excuse. Yeah, I just think we need to. I think it's great Michigan's open for business. It should not be open for this business. This is not really a business. It's kind of a Ponzi scheme. And Michigan should not be left holding any kind of bag when ultimately these data centers go bust. That's all I have to say. Thank you.
Thank you, sir. Up next, we have Katie Schneider. Katie Schneider, if you can unmute your mic, we'd love to hear from you. Ms. Schneider, if you're speaking, we can't hear from you. It looks like you might still be muted. Give it just a couple more seconds and see if we can resolve these tech issues. Katie Schneider, if you are trying to provide public comment, we'd love to hear from you, but we can't at this point. Okay. As a reminder, can you try unmuting your device? See that you've got your hand up still, Katie Schneider. We are unable to hear from you. Okay, I would note that I apologize for the technical challenges that we seem to be having. I would note that we can continue to submit written comments via email, and that address again is lara-mpsc-commissioners@michigan.gov. So I'll try one more time to see if we can get Katie Schneider. Okay, well, we will at this point conclude the public comment period of today's meeting. And again, that email address for written comments is lara-mpsc-commissioners@michigan.gov. A few announcements before we close out today. First, in some bittersweet news, today is the last commission meeting for one of our outstanding attorneys in our Regulatory Affairs Division, Jana Bachman. Ms. Bachman began work at the commission in January of 2011, but her service as a state employee with the state of Michigan goes back to July of 1978. At the commission over the last 14 years, Ms. Bachman has been the primary attorney responsible for reviewing matters involving residential customer complaints and for all licensing proceedings involving telecommunications. During her time at the commission, she has handled countless prima facie determinations multiple rulemakings, and has been recognized as an expert regarding our billing rules. Her contributions to our work have been immense, and just over the past 5 years, Ms. Bachman has drafted a combined total of over 200 orders and minute actions. That's nearly one a week over the last 5 years alone. And on a personal note, I doubt that you'll ever find a kinder individual than Ms. Bachman. I certainly have enjoyed each of our interactions during our time together, and I'll miss her warmth, her friendship, and her good humor. She's had a remarkable career, and we will miss her. So thank you, Ms. Bachman, for your 47 years of outstanding service, and we wish you all the best in your retirement and future endeavors. Second, I want to officially congratulate and welcome back to the Commission Daniel Gottschalk, who was recently named manager of our rates and tariff section, succeeding Nick Revere, who held that post for a number of years after Nick was promoted to director of the Energy Operations Division earlier in the year. For the last 2+ years, Daniel has held the position of Senior Rate and Business Consultant with the National Rural Utilities Cooperative Finance Corporation, but previously Daniel spent nearly 12 years with the Commission, starting as a student assistant in the Renewable Energy section before being hired full-time as a departmental analyst in August of 2013, and then promoted to the position of Electric Cost of Service Specialist in October 2018. So welcome back, Daniel. We're excited to have you back in this management role. And then finally, I want to also welcome back Administrative Law Judge Teresa Staley, who returned to the Michigan Office of Hearings and Rules as an ALJ overseeing commission proceedings earlier this fall. Judge Staley previously served as an ALJ with Moore's predecessor agency from 2010 to 2014, where she presided over the same subject matter involving complex contested case hearings on behalf of the commission. During that time, since that time, Teresa's practice has remained focused on utility law, including electric, gas, and telecommunications, both as senior counsel in 2 private law firms and as in-house regulatory counsel for a major utility company. So thrilled to have your background both with Moore's predecessor agency as well as with a deep understanding of energy law and regulation. And we welcome you back, Judge Staley, as well. I believe that's it for my reminders. Anybody else have anything today? Okay, well, with that, our next commission meeting is scheduled for Friday, December 5th, 2025 at 1:00 p.m. Is there a motion to adjourn?
I move to adjourn today's meeting.
I second the motion.
We will now have a vote on the motion to adjourn the meeting. All those in favor say aye.
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 Aye. Any opposed? The motion carries by a unanimous vote. The meeting is adjourned. Thanks, everybody.